Case number 24690D. We're here for a final pretrial and a motion on that one. And then we are here for a pretrial on 254015SM. Appearances, counsel?
Nick Carnes on behalf of the people. David O'Mara on behalf of Mr. McInerney.
And go ahead, I'm sorry.
Adriana Taylor and Anna Prevent, supervising attorney.
Thank you. Is there any resolution on any of these cases or matters?
No.
No? All right. So Ms. O'Mara and
I apologize. Briefly, we did receive an offer from the prosecutor just before coming on the record today. We were in the process of discussing that, but we were brought in before we were able to get to a resolution. However, the prosecution has generously agreed to hold that offer open following today's hearing for us to further discuss. Thank you.
okay. We are here on a defense amended motion to dismiss the charge. Ms. O'Mara, I believe this is your motion.
Yes, Your Honor.
Argument?
Your Honor, pursuant to the brief that I submitted, the prosecution's only evidence that they've provided of any impairment due to intoxication is a mere presence of THC in the bloodstream. No field sobriety tests were taken. No limited interview of the suspect or the defendant was taken. There's no one witnessed the accident. There was no police contact or reports before the accident of driving irregularities. The mere presence of THC in the bloodstream has been demonstrated to not be adequate to prove beyond a reasonable doubt that there is a charge of operating while intoxicated or a charge of operating while visibly impaired, which the prosecution mentioned in their response that they were also planning on including the language for it if we went to trial.
The impaired. The impaired?
Yes.
Yep.
There are cases that establish that the same standard for medical marijuana that was in effect following the 2013 decision continues in effect, or is basically the new standard for 2022 for recreational marijuana as well. I believe the language was added pursuant to that. So basically my argument is that the prosecution has presented evidence sufficient to show that any reasonable trier of fact could find Mr. McInerney guilty, and no evidence is in existence that could do so.
So Ms. O'Mara, what authority do I have to dismiss a case? I mean, it's not like this is a felony and going to the pretrial stage where I could find that there's not probable cause. Essentially, what you're asking me to do is prior to any type of trial in this case, me stepping into the trier of fact and determining that there's no case to move forward with. So what authority can you cite me to that allows me to do that?
Well, my argument would be that there is no question of fact presented, that there's no.
But how do I know that? I haven't been presented with any of the evidence.
Well, I mean, some evidence has been entered onto the record in our previous hearings.
What previous hearing is that?
Our previous pretrials. Sorry, if you view the evidence, we would stipulate for the purposes of this hearing, the viewing of the police report, our argument is that no evidence will be presented or has been presented that could establish, not presented, even assuming the facts that the prosecution alleges, there isn't evidence sufficient to form any probable cause or reasonable basis for the charge.
But are you not, in essence, asking me today to step in the role of a juror or the trier, in fact, to determine whether or not there's enough evidence for the case? That's essentially what you're asking me to do, correct? I mean, you're asking me to determine whether there's enough evidence to essentially convict Mr. McInerney, or at least present a triable question of fact for that, correct?
Correct.
And so because this is a misdemeanor, what authority can you point me to that says I have the authority to do that? You cited some case law, but those case laws seem to deal with felonies and not misdemeanors.
I mean, I believe the case law that I introduced all the OWIs, which is the same charge.
Is that the Kuhn case you're talking about as far as the marijuana?
I don't think that was the only case that I apologize. I was citing People versus Augustus Jones, People versus Williamson. Trial courts may dismiss criminal charges over the prosecutor's objection when they were permitted by statute or where there's insufficiency of the evidence.
And so what were the factual situations in those cases?
Suppose that was to grant a new trial.
That was what, I'm sorry?
It was a motion in granting a new trial, so
Okay.
that was after trial.
I mean, I believe I have the authority to dismiss when, as I've said, there's a preliminary examination and I've heard to determine whether there's probable cause. I decide whether there's probable cause or not. But even then, when I dismiss, it's without prejudice, so the case could be brought back. Then there's situations in some of the cases that were cited in which there's prosecutorial misconduct or abuse of discretion. I've got the authority to do it there. But just when the parties seem to have a differing view, I mean, Mr. Carnes filed a response today that kind of outlined in more detail what they could present as far as evidence to go to an operating while intoxicated or even operating while visibly impaired. But I could not find a statute, nor could I find case law that is authorizing me to do what you're asking me to do under this set of circumstances with a misdemeanor. Were you able to find anything?
How about People versus Nunez? Was the district court would abuse its discretion in allowing the case to continue with failing to distinguish between a suspicion of guilt and a reasonable belief that the defendant is the person who committed a crime. That was dealing with an OWI case. Mere suspicion is not the same as probable cause. Although I will admit, I believe that was on a motion for directed verdict.
So that would have come after trial, or at least during trial.
I believe so, yeah.
Okay. And doesn't, forgive me, it's been a couple days since I looked at this, but doesn't People v. Dupree, I know you argued in your brief that People v. Kuhn, which is the medical marijuana case, says that there has to be more than just THC in somebody's system. We have to actually, the prosecution actually has to show that there's some sort of an intoxication due to the marijuana being in the person's system. But doesn't People v. Dupree, and I'm sorry, I don't have a site here. It's 335 Mishap 126 2020. Doesn't that say that the medical marijuana statute only applies to the intoxicated portion and not the visibly impaired portion? That a prosecutor could still move forward on a visibly impaired if the person had their medical marijuana card. And then I think it's People v. Perry. I think it's Perry. 338 Mishap 363. I think that's the case that made essentially the same requirements that are required under People v. Kuhn pursuant to the Recreational Marijuana Act. So they would still have to show some sort of intoxication. But because they use the same reasoning in the MMA, the Medical Marijuana Act, would not People v. Dupree still apply to that and say that you wouldn't necessarily have to show signs of intoxication for visibly impaired, should the prosecution decide that they want to move on with the lesser included offense of visibly impaired as opposed to the operating while intoxicated?
And I mean, correct me if I'm wrong, but I still believe that there needs to be evidence outside of the fact that THC was in his system or the defendant's system, or could be shown to be in the system. My point was that there's no other indications, there was no other evidence collected. Even there was just there was no field sobriety test. There were no all that they functionally have is this blood draw and the fact that a crash occurred. And I don't think that counts to more than a mere suspicion. I don't think that where are you going to get the visibly impaired aspect of this with no field sobriety tests? Where are you going to get?
Well, can people not pass? Well, there's no pass and fail on field sobriety tests, but in essence, can't people pass sobriety tests and still be visibly impaired? The sobriety tests get you to a level of intoxication, right? That says you're intoxicated. But and I don't know the facts of this case at all, but I'm just throwing out some questions for you. We've all seen drunk people. They might not rise to the level of a 0.08, but is slurred speech a sign of maybe being impaired? Is stumbling being a sign of impaired? These are just things I'm asking, and those are things that I don't think it should the prosecution decide to move forward on a lesser included, they might not have to show the field sobriety test to get to the intoxicated level, but would probably still be able to show an impaired level.
And I mean, I guess I would of course disagree with that, but my point is less so that obviously I'm not arguing that because it's circumstantial evidence that isn't evidence. What I'm arguing is that the circumstantial evidence that they have in addition to this blood draw is nothing that would demonstrate, or nothing that could possibly demonstrate to any reasonable trier of fact that the defendant was impaired. I don't believe that evidence has been introduced that any reasonable trier of fact could come to more than a mere suspicion. And I think that if it's not more than a mere suspicion, you do have the authority to dismiss.
So I want to be clear because we're using some words. So evidence to me means that I've sat here and I've taken testimony and I've been presented with evidence. I haven't had any of that from what I've had. And I'll be honest, I don't remember anything about these cases procedurally where we've been so far, but to my knowledge, we have not had an evidentiary hearing. Am I right on that, Mr. Carnes? And so what you're saying is based on what's in the police report, correct?
Correct.
That there's not enough to move on. But that isn't evidence so far. I mean, the court, I have not heard any of that yet. So I don't think it's necessarily evidence.
If I might consult.
Sure.
Like I believe I was saying earlier, we would stipulate to the entry of the police report for the purposes of this hearing. And for the sake of argument, we would stipulate that for the purposes of argument, that anything that the prosecutor, can bring in would be factual for this hearing, for this motion. I think that even if you assume everything that the prosecution is alleging is factual, that there would not be more than a mere suspicion. That there would not be probable cause.
So let me ask another question. Even if I do that, I think we can all maybe agree that not necessarily all the facts are contained in the police reports, right? I mean, we see police reports all the day that somebody might get on the stand and testify to something that wasn't contained in the police report, or they might testify to something different that's in a police report. Does that not still put me in a position of a trier of fact before we go to trial?
I mean, if for the purposes of the hearing, all the facts are stipulated, I don't think you're making a decision on the factual.
Aren't you asking me then to make a decision as to the likely outcome of the case, which would put me into a trier of fact position?
I don't believe that asking you to, or making the request that I'm making, puts you in the position of a trier of fact. I think that, it's, let's say hypothetically, I accused, Nate of doing some crime. I had, nothing to show, or I didn't have any sufficient evidence to show. You wouldn't, just because that crime is alleged, there would be some level or standard that you could use to throw that case out. You wouldn't simply because something could come out at trial that changes what is being alleged doesn't mean that we have to take it all the way to trial. It doesn't mean that there isn't a standard here. I don't. I'm sorry, I don't have it off the top of my head.
But what is the standard? I guess that's what I'm asking, because I know the standard for a felony is probable cause. That's why we have preliminary examinations. And that's why when there's a request from the prosecutor's office to issue on a felony charge, they either go on the record, law enforcement either goes on the record with it, swears to it, to the allegations, or we have a probable cause affidavit that's sworn, laying out the factual allegations, and either the court or the magistrates determine whether there's a probable cause to issue the felony. And then we come in and we have a preliminary examination, and then I make the decision as to whether or not there's probable cause to move the case forward. That's for felonies. That's specified by court rule and statute. That's a procedure we have in place. We don't have that same procedure in place for misdemeanors. So what I'm asking you is, what authority do I have for a misdemeanor to do what you're asking me to do? Because otherwise, if I'm doing what you're asking me to do, essentially what you're asking me to do is to remove myself from the judiciary branch, put myself back, and when I say back in, because we all know I was the prosecutor for a number of years, put myself back into the executive branch, substitute my decisions for the charging decisions of the prosecuting attorney, which goes completely against the Genesee County prosecutor case. Judiciary can't overstep its bounds and override decisions of the prosecutor, except in very limited circumstances. So that's what I'm asking you. Does this fit one of those very limited, narrow circumstances that I have available to me?
Sorry, give me a minute.
Sure.
I cannot immediately or quickly, in respect of the court's time, find the authority for that. There is authority that we can set an evidentiary hearing to determine the veracity of the probable cause in this case.
For a misdemeanor case?
But, yeah,
What's that authority?
it was 207 Mish at 486. People versus
7 mishap. What was it?
207 Mish at 486.
What was the case?
People versus Fish.
Fish?
Yeah, Fish. Like,
Anything further?
I have nothing.
Okay.
Further, I suppose. No,
All right.
I do not have anything further.
Mr. Carnes?
Your Honor, I would ask the court to deny defendant's motion, both because I don't think there's authority to do that, but also I think that people do have sufficient evidence to submit to a trier. In fact, I do take issue. We do have eyewitness testimony that saw the crash, or at least did what happened immediately thereafter. I think that's relevant. We have an expert in toxicology testify as to levels. I did speak with her on the phone this morning to get a better idea of what she can testify to. I feel like I have a stronger case, as I've outlined in this, as I turn this in after. So I would just ask the court to deny the motion. We have police witnesses, lay witnesses, an expert witness, bad driving. I think there's certainly enough evidence to reach a trier of fact.
So let me ask you about your expert witness, Mr. Carnes, because I saw that in your response today, and she's the forensic scientist from the lab.
Yes, Your Honor.
And normally they are used just to explain their analysis to determine what, in this case, would be contained in the defendant's blood, correct?
Yes, Your Honor, although they, she did, and I did receive an update from the Traffic Safety Department of the Prosecutor and Attorney Association of Michigan, stating that these experts can regularly testify about what various, basically the various levels of THC could mean as far as recency of use. And in this case, we do have 11-hydroxy delta 9 THC, which dissipates even more rapidly than delta 9 THC. As well as a relative level of carboxy THC, which is relatively low and is an indicator of intoxication. According to him. Obviously, the carboxy is not admissible to show that the defendant was intoxicated because it's not an intoxicating substance. However, a low amount like we have here would show defendant is not a chronic user and could suggest that he would be more intoxicated by these THC levels than would a chronic user. And again, this expert believes that that is all relevant information to present to a jury. She has presented that kind of information to other juries.
The only reason I'm asking is because that's so far out of the norm as to what we generally use the forensic scientists from the laboratory to opine on. I think then under 6.201, there'd have to be some sort of written report or written summary as to what she, or a summary of what she's expected to testify to and the opinion she's expected to give, which then brings, I'm going to jump ahead here because I haven't ruled on this motion. But if I do rule against the defense, then is defense going to, and I'm going to jump to you, Ms. Amira, are you going to request additional time to consult your own expert to counter what the prosecution's expert is going to potentially testify?
Yes, sir.
All right. Mr. Carnes, correct me if I'm wrong. This is a case in which allegedly the defendant crashed into a house?
Yes, Your Honor, that's correct.
And this was in June?
Yes, Your Honor.
All right. And you say you have witnesses to the accident?
Yes.
Are those witness statements contained in the police reports?
Some are contained in the police report, more are contained in the body camera video. If an adjournment is granted, I intend to ask police to review their body cams and make contact because I don't think I have a full witness list in the police report at this time.
Have you turned over the body cams to the defense?
Yes, Your Honor, that was turned over on June 18th.
All right. Anything else?
No, Your Honor, thank you.
Any rebuttal, Ms. Amira?
I apologize. There is authority that exists governing motions for dismissal. This would be MCR 2.504. It basically puts you on the civil rules Section 9.9 of the bench book.
So what specifically in 2.504 applies to this?
Your Honor, I believe that a record has been made for this motion. It would ask that you rule on it. I don't, um, without floundering here for a good amount of time, I can provide you with any more information than I already have.
All right, the court is going to deny defendant's motion. I do not believe I have the authority to grant the relief requested. This is not a preliminary examination. This is a misdemeanor charge. I believe that asking the court to make a decision as to whether or not there's enough evidence to move the case forward in a misdemeanor is not appropriate. The court has not received any evidence. I've not heard any testimony as to what evidence is out there that would be presented at trial. The gravamen of the motion was essentially that because it's alleged that the defendant was operating a motor vehicle while intoxicated by marijuana, that the people would have to show through field sobriety tests that he was in fact intoxicated. As we discuss the case, I believe that does not necessarily have to be shown through field sobriety tests. Well, that's a tool. The jury is instructed that they can use their common sense. They can use circumstantial evidence to determine whether or not somebody is in fact has violated a crime. Additionally, the prosecution could always request a lesser included offense. I'm not saying that they would, but if the evidence panned out, they could request a lesser included offense of operating while visibly impaired, which my reading of the court of the cases of, I believe it's Dupree and I can't remember the other one now, but would make the those requirements not applicable in an operating while visibly impaired case under the marijuana statutes, because the marijuana statutes only dealt with intoxicated, not impaired. Additionally, I believe that the defense is asking the court to step into the role of the executive branch in making charging decisions and case resolutions, which I believe that this court does not have the authority to do under the Genesee County prosecutor case. So as such, the court is going to not grant the defense motion. Mr. Carnes, can you do an order for that, just for the reasons stated on the record?
Yes, Your Honor.
That brings us to my next question is whether or not the parties want to continue to talk about a potential resolution, or because it sounds like there's a request for, or maybe the need for expert witnesses in this case, whether or not we want to set this for another final pretrial. I'll turn it over to the defense.
We'd ask for another final pretrial.
Any objection to that, Mr. Carnes?
No, Your Honor.
All right. Let me make some notes here. Mr. Carnes, do you plan on having your expert do a written report on levels of intoxication by THC, or what you have anticipate her to testify to, or just a written summary?
Your Honor, I imagine a written summary would be appropriate in this. She did state she's not allowed to opine as to effect on the actual defendant based on what she has, but rather just in general.
Correct.
I think a written statement would be appropriate in light of that.
All right. How do you have any idea as to how long would take her to do something like that?
I'm not sure, Your Honor. I would imagine we could get this back on. She was very readily available, so I would imagine if we set it out for October's final pretrial date, that should be sufficient time.
That's October 16th, so a month away. Ms. O'Mara, do you think that's going to give you enough time to receive the report and her summary and discuss with your potential expert?
I don't really have a lot of experience dealing with experts through our office, but I believe so, yes.
I'm going to err on the side of caution and set this for November final pretrial. Just because my experience is it's not as easy to retain an expert as one thinks. So we will set this out for November final. Okay, so that takes care of that case. We'll get that on the November final pretrial, and then that brings us to the new case, or the newer case for a pretrial. Do the parties need time to talk on that, or are we going to set that for a final pretrial as well?
Yeah, I think it makes sense to set that for a final pretrial as well.
I would agree.
You want the same final pretrial or a different final pretrial date?
I think that setting this one for the October final pretrial makes sense. I don't see any expert witnesses.
They're not tied at all together. Ms. Fiorvento?
I would say the November final pretrial for both, Your Honor, because the offer that was given to us before coming to record today would have been a global resolution. I am optimistic parties may be able to resolve this. And in the event we strike the plea sooner, would it be okay if we emailed your office to ask to move up a plea and sentence date?
We will always take a plea and sentence.
Your Honor, I was just next going to put an expiration on that global offer. I think the October final pretrial date still makes sense for the your file.
All right. Well, given that the two cases are separate, the court is going to keep the newer case 4015 on its normal pretrial track. So we'll set this for an October final pretrial. The parties can always reach a global resolution. And Mr. Carnes, given that this is the people's offer and it has not been accepted, can always put a deadline on that, so if they so choose. That's not to say if we get here in October and there's still more time needed and the parties are still working towards a resolution, that's not to say I wouldn't grant another request. It's also not to say that I would either, just so we're all clear on that. Mr. McInerney, you can go out to the front window where you checked in. I know a lot happened today, so you might want to talk with your client, your attorneys about what happened. Just a reminder that your bond conditions continue, okay?
All right.
All right, thank you.
Thank you, Your Honor.
Yep.
All right, let's talk about that. This pretrial hearing for Mr. McKinney wasn't flashy, but it gave us a deep dive into how judges navigate motions that ask them to step a little outside their lane. Judge Middleton had the task of hearing a defense motion to dismiss an operating while intoxicated case tied to marijuana use, and the exchange showed both sharp legal sparring and the judge's trademark insistence on staying within his authority. Counsel argued hard that the state's evidence boiled down to a single THC blood test, with no field sobriety tests, no officer interviews suggesting impairment, and no eyewitnesses to irregular driving. Their position was that this amounted to nothing more than mere suspicion, and that the judge had the authority to cut the case off at the knees before trial. It was a creative argument, citing cases that dealt with marijuana and intoxication standards, but Judge Middleton pressed back. His questions boiled down to, even if the facts are thin, is it really his role at this stage to substitute his judgment for what a jury might decide? The pro-E prepared, highlighting that they had more than just the lab results. They referenced eyewitness testimony of the crash aftermath, police reports, and an expert toxicologist ready to testify about THC levels and their impact. They even detailed how certain compounds in McKinney's blood could suggest recent use and greater impairment for a non-chronic user. That was enough, in their view, to get the case in front of a trier of fact. Middleton seemed skeptical about how far an expert could stretch their testimony, but he acknowledged the state had at least outlined a plausible trial strategy. The defense pushed, pointing out that introducing circumstantial evidence without real observations of impairment wasn't enough to meet the threshold. But Judge Middleton ultimately denied the motion, explaining that in misdemeanor cases like this, there's no built-in preliminary exam process like with felonies. To dismiss now would essentially make him a stand-in prosecutor, second-guessing charging decisions, and that's not a power the court can freely exercise. He emphasized that juries can use circumstantial evidence and common sense to decide impairment, even without standardized field tests. What made the hearing especially was the tone. The lawyers stayed respectful, but the judge's questions carried a subtle mix of curiosity and skepticism. You could almost hear him saying, I get what you're arguing, but show me where the rule book says I can actually do this. When the defense couldn't, the outcome was clear. To balance things out, he gave both sides extra time before trial, especially since expert testimony was on the table and the defense might want their own specialists to counter the prosecutions. Overall, the courtroom atmosphere was C8 and rooted in legal nuance rather than drama. No raised voices, no grandstanding. Just a careful debate over what qualifies as enough evidence to move forward. Judge Middleton's ruling reinforced a theme we've seen before. He's willing to question both sides closely, but at the end of the day, he won't overstep into roles that aren't his. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.